Hello, everyone. We hope you're doing well during this time. My name is Nathan Holloway, and I'm an associate here at Robbins Appleby in the Business Law Group, and I welcome you to the first webinar first webinar in our Coffee Time with Robbins Appleby series. Throughout the series, we can all sit back, relax, get comfortable, and grab a coffee while we chat about a number of legal issues that might be relevant to your business both during this time and as things start to return back to normal. So today I have with me my colleagues Jonathan Zepp,
Hey, Nathan.
Charlie Kim,
Hey, Nathan.
and Ishmael Ibrahim,
Hello, everyone.
all of whom are in our business law group as well, and they will be providing their insights. So many of us have been working from home for the past couple months and probably will continue to do so for the foreseeable future. And in the past few weeks, we've also seen a number of large businesses and banks announce that working from home will become a permanent arrangement for many of their employees. Your business may also be considering the same or a similar arrangement. However, in making this decision, it is important to first be aware and consider the legal issues that arise, in particular, confidentiality and privacy concerns, which is the topic of today's webinar. So the first question we received, I'll put to Charlie. So what are some of the issues that arise as a result of employees working from home?
So Nathan, the issue is that as the work from home arrangement is becoming the new normal for many employees, there's a real concern over how the companies manage the risk to their data protection and confidential information. And the companies certainly have added obligations to safeguard their property and information. And this added obligation really results from the employees taking files to their home, accessing confidential materials through unsecured networks, and having meetings through unsecured means. It also comes from using personal or shared devices for work purposes, or even forwarding files outside the company servers. Although most businesses have their existing confidentiality and privacy policies in place already, it's unlikely that these policies have adequate measures for long-term work from home arrangements. Suffice to say, if the companies have not already done so, they should really review and update their existing policies now.
Right, and thank you for that, Charlie. And so the next question I'll put to Jonathan and Ishmael. So what are the sources of the privacy and confidentiality obligations that businesses should be aware of?
That's a good question, Nathan, because, the privacy obligations have to come from somewhere. They actually need a source. And, there's a few sources. I'll review some of them, and then I'll ask Ishmael to step in. But the first source would be contracts. So everyone may be familiar with the term non-disclosure agreement, and many companies are parties to it either to protect their own information or protect information from others. There may be confidential provisions which are similar to the non-disclosure agreement, which are contained within contracts. And so particularly long-term contracts often have non-disclosure or confidentiality provisions. And lastly, there are some professions which by the very nature require confidentiality, and these are usually contained in professional codes of conduct. So lawyers and accountants, for example, would have those obligations within their professional codes. Ishmael, maybe you could talk a little bit about the source from statutes and common law.
Thanks, John. When we talk about statutes and common law, there's 3 points that we need to consider at the top. The first being that the laws related to data protection and privacy are complicated and governed by many different acts and regulations. The second is that most of these acts and regulations relate to personal information and not to commercial information. And finally, these laws are still evolving. We don't have the benefit of a lot of case law to help guide us with respect to the laws. With respect to personal information, the main piece of legislation that everybody should be aware of is PIPEDA. So PIPEDA is a federal act that governs personal information held by federally regulated organization. This act also governs commercial activities in all jurisdictions that do not have substantially similar legislation. So Ontario, for example, is one of those jurisdictions that doesn't have similar legislation related to commercial activities. FIPA, NFIPA, and PHIPA cover other areas, but not commercial activities. So under PIPEDA, generally information must be protected by security safeguards appropriate to the sensitivity of the information. So items that are more sensitive, example of such as health information or SIN numbers, require more safeguards than other items. So what are these safeguards? They include physical, organizational, technological. Generally, the organization should exercise the right amount of due diligence. Because if they don't, the privacy commissioner is empowered to receive complaints, investigate, and issue remedial orders. They could also impose fines and penalties. If the commissioner makes a ruling on an organization's statutory compliance, the legislation permits impacted individuals to sue in court for damages as well.
So Ishmael, I'll just interject there. So you're telling us a lot about the statutory protections for personal information, but what about business information? So Jonathan was saying earlier the importance of contracts, but what other protections are there, if anything?
So as Jonathan mentioned, contracts is the main avenue for individuals. There are a number of torts people have tried. There's a hodgepodge of advanced claims. They include the intrusion upon seclusion that was established under the Jones case in 2012, the privacy tort of public disclosure of private facts. But generally, the breach of contract and negligence are the main torts where people try to advance with. What employers also should be aware of is vicarious liability, where an employee negligently carries out their duties and puts personal information at risk. The employer can also be liable under vicarious liability.
Right. So knowing the sources then, what are the obligations that businesses should be aware of, both as an entity disclosing information and an entity that might be receiving the information?
So as an example, you look at the tort of negligence. So there is a general duty on organizations to protect personal information collected for a commercial purpose, where it's reasonably foreseeable that harm could result from a data breach. So what is the standard of care here? It's a reasonable care, it's not perfection. And courts will look at the seriousness and probability of the risk that was involved and the cost that would have been to prevent or mitigate against that risk. What are the common practices in the sector? And also look at if there were any statutes and what was the compliance. In general, though, everyone should be aware that that enforcement in courts is always going to be an uphill battle. So it's good to make sure that you have those contract provisions.
Yeah, and that's a good point as well, because the point of how you're going to enforce it and what obligations parties have are ambiguous, particularly when you're dealing with commercial confidential information, at best. And so the best thing really is to have contracts which set out the obligations that are you're required to maintain, or policies that you're required to maintain in order to maintain confidentiality. And you have to look at it from both directions. So you may be the one who's required to keep information confidential, but you may also be the one who is giving confidential information to others, perhaps your suppliers or your customers. And you want to make sure that you have contracts that specifically outline the obligations, the duties, and the steps that are required in order to keep information that you want to keep confidential, kept confidential. Charlie, but how would people do that?
So, Jonathan, companies should be concerned about safeguarding both its own confidential and private information, as well as information that has been disclosed by a third party through the course of their business dealings. There's three key points here that I want to address. The first is obvious: have a policy in place. At a most basic level, the business must have a policy in place that provides both a clear and consistent guideline for ongoing protection of company property and information. For example, the policy should include rules about what files can be taken home, secure VPN access, password protections on files, destructions of documents after use, secure storage of files at home, and limiting use of company devices for work purposes only, as well as restrictions for forwarding files outside of the company servers. Look, if you have an effective policy in place and an employee does something that results in data breach or disclosure of confidential information, that policy will provide a basis for reprimand. Whereas if you don't have a policy in place, it just makes it that much more difficult to take disciplinary measures. The second point is that the policy must be practical. It's never going to work if the policy simply looks good on paper, but is impossible to implement. It's important to have discussions with your employees to ensure that you're not putting anything in your policy that can't be followed. For instance, the company should ensure that employees are well equipped with devices required to operate from home, that they're investing security measures such as VPN that's required to implement the policy, and to also provide necessary IT support to the employees on an ongoing basis. It's also a good idea to reach out to businesses within the same industry to get a sense of what they've been doing, as well as determine if there's any industry standards or best practices that has evolved since the beginning of this pandemic. The third point is that business must ensure that the policy is actually being followed. There has to be an adequate training given to the employees, and employees should maintain consistent and constant line of communication with the employees after the training to reinforce that policy. But most importantly, it has to be a top-down approach, and the management has to lead by example. It's going to be a tough sell to convince your employees to follow a policy that's not being complied by the leaders of the company. In addition, the company should solicit feedback from the employees, whether through a survey or group discussion, and make any changes that would improve the policy. I would leave it with my final recommendation in that spot audits, should be done to monitor compliance, including audits of what files are being forwarded out of the company servers.
Right, and thank you for that, Jonathan, Ishmael, and Charlie. So from what we've heard, there are a number of confidentiality and privacy issues that businesses need to be aware of in allowing employees to continue to work from home. Businesses may have obligations as both a disclosing party and a recipient party, and such obligations may arise from a variety of sources, including contracts, statute, or the common law. So where those obligations or protections exist, businesses need to be cognizant and take relevant steps to protect the information, whether that information is personal information or business information, in order to avoid liability or risk. However, where there are no protections in place, or any protections provided by the common law or statute, then you may need to consider putting such protections in place through contract in order to protect that information. So we hope that this video has been helpful for you, and please keep an eye out for the next video in this series. You can also go to our website at robinsapplebeet.com to find additional videos, blogs, and articles that you might find relevant to you and your business. Thank you for joining us today.
Bye. Stay safe.
Bye.
Take care.
Bye.